Oh my God, it's been a long time. All right. Hello, everybody. Doug from Salt Lake. So, we have not put up a video for a while because of the COVID, the cerveza bug, the scam-demic that's been going on. So, we filed, last time I was making a video, we filed a bill in equity, amended complaint, in the 3rd District Court. And we now have Andrew H. Stone. And we're going to see now if this guy is real or not. And so let's go through a couple of things. So if everybody remembers, we're doing a bill in equity in the 3rd Judicial District Court. And we went through this. We did an administrative process with them. And we filed this. And of course, we got the inevitable motion to dismiss. And we're going to go through that here in a minute. Remember, always put your certificate of service. And this is what I put in there. Notice of acceptance, notice of default, certificate of non-response, declaration by affidavit, and a verified affidavit of default. So all this went to the courts, and of course we got the inevitable motion to dismiss. But first, because I knew from experience what they were going to come up with, so let's just go through this. Okay, so you come in as the real party under Rule 24A, intervening in motion as the authorized representative, hereby invokes a court of equity, requests this court to take judicial notice of the following precedent. What's precedent? Stuff that's already been decided that they have to go by from upper court rulings. Praises court provide justice and fairness. Motion contains a memorandum of law showing definitions, assertions, and proof. His initial complaint bill has created an equitable estoppel. A man, American, also states for the record that I reserve all my rights and any presumed joinder, we'll talk about joinder too, to a legal fiction is hereby revoked, rescinded, made void for lack of full disclosure. I accept your oath, Andrew Stone, and I respectfully ask you to uphold your oath. So, to wit, so these are a couple of case laws, and we'll just go through this as quick as I can. So pro se pleadings, as always, will be liberally construed. Okay, pro se litigants still must allege sufficient facts in their complaints to support a claim. Of course, they always say 12b-6, failure to state a claim, and we'll get to that. That is, all civil complaints must now set out sufficient factual matter to show that the claim is facially plausible. Plausible on its face. This then allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Okay? I have entered enough sufficient factual matter to survive the inevitable motion to dismiss, and I will respectfully demand that this court allow me to be heard before dismissing this case. All the court has to do is look at the administrative process and rule on its validity. I am not asking for the court to enforce the obligation or as agreed to, but I am asking that a judicial authority give the plaintiff relief pleaded in equity as summary judgment. Second, court should determine whether the remaining well-pled facts sufficiently so that the plaintiff has a plausible claim for relief. In deciding a Rule 12b-6 motion, the court must accept all factual allegations as true, construe the complaint in the light most favorable to the plaintiff, and determine whether any reasonable reading of the complaint the plaintiff may be entitled to relief. A complaint does not fail to state a claim unless it appears to a certainty that the plaintiff would be entitled to no relief under any state of facts which could be proved in support of the claim. To survive the court's screening for failure to state a claim, the complaint must allege sufficient factual matter to show that the claim is facially plausible. Summary judgment is appropriate if the pleadings, that's my pleadings, affidavits, I'm the only one who's filed any affidavits, and other submissions, that would be my process, of the party show that no genuine issue of material fact exists and that the moving party is entitled to judgment as a matter of law. That's Rule 56C. Okay? And there's all the case law. As stated in the process, ORS was already given an opportunity to cure their dishonor. Statements and motions unsupported by affidavits filed by third parties, which would be the AG's office, are not sufficient for a motion to dismiss. And there's Trinzi versus Pagliaro. That's a great one. And see Bill and Equity number 37, because I already put that in there in the original pleading. I'm not even going to try to say that. Whenever there is a doubt between liberty and slavery, the decision must be in favor of liberty. So here is judicial notice of precedent. The term liberty denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, to establish a home, and to bring up children, to worship God according to the dictates of his own conscience. The established doctrine is that this liberty may not be interfered with under the guise of protecting public interests. See, there's individual and there's public. By legislative action. Meyer versus Nebraska, and that's the 262nd volume of the United States Reporter, page 390, 399, and 400. Silence can only be equated with fraud where there is a legal or moral duty to speak, or where an injury left unanswered would be intentionally misleading. That's a great one. U.S. versus Pruden, Carmen versus Poe. Okay? ORS does not have immunity or sovereignty. 45 CFR, Code of Federal Regulations, 30212A. The state plan shall provide for the establishment or designation of a single and separate organizational unit to administer the 4D plan. Such a unit is referred to as the 4D agency. Under the rules of statutory construction, it is safe to conclude that what is included is done with purpose. The language of Title 42 is very specific, single, and separate. ORS is a single, separate, unit, entity, agency, franchise, corporation, entirely separate from government, and they are not protected by edicts of legislation. Writing down words on paper and calling it immunity does not survive scrutiny. They have customers, they provide a service, they collect debt for third parties, and they have a mission statement. ORS is not sovereign or immune to action. Because they are a third-party bill collector, they are also bound by the FDCPA, Fair Debt Collection Practices Act. Every U.S. Court of Appeal that has addressed this issue has held that child support is a common commercial debt subject to all debt collection procedures under the Fair Debt Collection Practices Act. See U.S. versus Luco, U.S. versus Parker. Also, if the United States waives immunity under the precedent seen below, and we'll get to that, for the reasons seen below, ORS waives it. Even if this court presumes ORS is a franchise of the state of Utah, all capitalized, a corporation, immunity still fails because they are contracting with citizens. And I probably should have put private citizens or individuals, but they're contracting with citizens. De jure governments protect private rights. So de jure is the real government. De post facto governments are administrative corporations contracting with citizens, and immunity is waived. And that is from Franconia Associates versus United States, U.S. Reporter in 2002. And they held, first, the requirement that the government unequivocally waive its immunity is satisfied here because once the United States, which is a corporation, see 28 U.S.C. 3215A, waives immunity and does business with its citizens, and ORS does business with citizens, it does so as a party never cloaked with immunity. And in Clearfield Trust versus United States, and pursuant to the Supreme Court, governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private corporate commercial paper and securities is concerned. Okay, so that's those Federal Reserve notes you got in your pocket or the checkbook you got in your pocket. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. The reason we're going through this, man, is they always say they have immunity. You can't sue us, we have immunity. Well, guess what? You're not immune. Okay? Since ORS is not the government, they cannot promulgate or enforce criminal law. They can only create and enforce civil law, such as Title 42, which are duty bound to comply with the law of contracts. The law of contracts requires signed written agreements and complete transparency. ORS contracts with the courts, law enforcement, attorneys, and with public. They are separate. They are a contractor, and there must be a contract for their services they advertise and collect fees for. The particular phraseology of the Constitution of the United States confirms and strengthens the principle, supposed to be essential in all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. In declaring what shall be the supreme law of the land, the Constitution itself is first mentioned, and not the laws of the United States generally. Now, what does that tell you right there? Right? That tells you that the United States and the Constitution are different. But those only which shall be made in pursuance of the Constitution have that rank. All laws, rules, and practices which are repugnant are void. Since the 14th Amendment to the Constitution states no state shall make or enforce any law which shall abridge the rights, privileges, or immunities of citizens of the United States, nor deprive any citizens of life, liberty, or property without due process or equal protection under the law. This renders, look at this, judicial immunity unconstitutional. Wow. Did you know that? I didn't know that. There is a general rule that a ministerial officer who acts wrongfully, although in good faith, is nevertheless liable in a civil action and cannot claim the immunity of the sovereign. Cooper versus O'Connor. And that right there is, so there's a federal law registry. It's like a lawyer's registry where they can go look stuff up. But I'll have to look that up. I forget exactly what it's called. So what are the parts of a contract? Parties competent, free and genuine consent, full disclosure, valuable consideration, certainty of terms, meeting of minds, autographs, signatures, and privity. Privity. Contract exists only between the parties. Is ORS, is child support, is the state of Utah, the state of Maine, the state of Texas. Are they a party to this contract? It was between you and your wife. It wasn't between them, but through some implied, undisclosed contract that you signed, you went to the state and you took your driver's licenses and your birth certificates in there and you said, here we go, we'd like to get permission from the government and here's all of our documentation. This is all your hearsay evidence that you need in order to get an interest in our private affairs. A contract exists only between the parties. No third party can obtain rights contained within a contract, buy or sell a contract without the expressed permission. It should say expressed written permission of the original parties. ORS is a third-party contractor collecting and enforcing without permission. So the state is to establish a single and separate unit. This language proves to the court that expression unius, exclusion ulterius, which means if one or more items is specifically listed, omitted items are purposely excluded. Okay? So why would it say single and separate? Why would it even say that? Why wouldn't it just say the state is to establish a unit? Because they are single. There is a reason this language is put into Title 42. The law is perfect and every word has meaning. They are separate. What does Black's Law say about separate, distinct, detached, unconnected, isolated, independent? Does that sound like they are part of the government? No. Solitary, unattached. Okay? They are single, individual, diverse, different, disconnected. Black's Law. Single and separate unit. They are not the government. The Fifth Amendment, Article 1, Section 7, states of the state of Utah requires that I should not be deprived of life, liberty, and property unless required. The requirement of the Fifth Amendment also says, and is present under 45 CFR 301-102 Sig 2, which clearly requires due process must be protected, and 42 U.S.C. 666A5CI, which also says that the state must afford due process safeguards. Okay? Title 42 has never been enacted into positive law, so it is considered prima facie. Well, what's prima facie? That's on its face, okay? Which means it's a presumption, it's an assumption, right? And if we have a contract with you, then it has the operation of law, but there's got to be something documented somewhere where you agreed to the terms and conditions. That is, until the presumption is rebutted and challenged. Once challenged, it must be decided. So, pursuant to the Federal Office of Child Support Glossary of Common Child Support Terms, page 11, you might want to look that up. You can get that from Ahmed Osiris. Or you can just go to the Federal Office of Child Support Enforcement Glossary of Child Support Terms, okay, and download it. I think it's 18 pages long. Due process is the principle of fairness in legal proceedings so that a person has a right to know what action is being taken and has an opportunity to be heard. Therefore, pursuant to my unlimited power to contract, as seen in the supreme law of the land, and the blah, 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 glossary of terms above, under Title 42 United States Code, Section 603 grants to states. It says clearly that you must have a contract, a commitment, and cooperation. Okay? And you guys should look all that up right there. Okay, 603 grants to states. You should read that whole thing. But it says in there, in the case of the non-custodial parent who becomes enrolled, just magically, I was enrolled in the project, right? I'm now in compliance with the terms of an oral or written personal contract. Look at that. There's the word. Okay? And at a minimum, you have to have all these. A commitment by me to cooperate. A commitment to cooperate. A commitment to participate. And then there's supposed to be a description of the services to be provided. Well, where the hell is all that? None of these minimums have been met. It also states on page 20 of the Federal Manual of Child Support Enforcement, proceedings conducted pursuant to either an expedited judicial or expedited administrative process must be presided over by an individual who is not a judge of the court. Therefore, child support is not a judgment because no judicial authority was present. Right? I mean, this is simple. Can't be a judgment if there's no judge. No judge, no judgment. It's not judicial, it's an administrative edict from a clerk, which is Michelle Tack, posing as a judge, working for the agency involved, ORS, when in fact when acting to enforce a statute and its subsequent amendments. So a statute, what statute? What statute are we talking about? I wonder if we're talking about this right here. This statute right here. When enforcing a statute and its amendments to the present date, the judge of the court is acting as an administrative officer, not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially. So how the fuck is it a judgment if there's no judicial authority present? And they know that because they're not acting as a judge. It's all a fucking fraud. Okay, sorry. Don't get me started. Anyway, there's the rest of it. Judges who become involved in statutes, blah, 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 act as mere clerks. It's accepted rule, not only in state courts, but federal. Judges enforcing administrative law is probably mere extensions of an administrative agency for superior ruling purposes. I sound like that guy Glenn from Sovereign Living. Federal law enforcement officer, unlawful action being committed against sovereign people, and these officers can be held personally liable. Bond versus United States, 2000. Once again, this is not an argument and not up for discussion. This is the law. Judges are not immune, and neither is ORS, because ministerial officers, okay, what is that? Michelle Tack, Chorus, who signed the divorce decree that implemented this fraud, are incompetent to receive grants of judicial power from the legislator. Their acts in attempting to exercise are nullities. Burns versus Superior Court, okay? When enforcing mere statutes, judges of all courts do not act. I mean, the case law is endless, okay? They don't have immunity. They don't have qualified, limited. They're not immune. They're not sovereign. They're a fucking corporation, okay? They're in it to win it. They're in it to make money. And finally, where any state proceeds against a private individual in a judicial forum, it is well settled that the state, county, municipality waives immunity to counters, cross-claims, and complaints by direct or collateral means regarding the matters involved. Okay? So when you come in there, okay, I think I actually wrote this in there. So which means when I come into this court, after making it very clear to all parties that I am appearing specially, okay, special appearance, I'm making a special appearance, intervening, 24A, non-joinder, right? I'm not a party, but I am intervening because I am the party in interest, and I am not joined to that all-cap name, reserving all my rights, appearing in my proper person. And I've made it very clear I am not the legal fiction all-cap name. I am a man. Then you must produce the contract I am obligated to perform under that I voluntarily agreed to. Period. ORS was given notice to prove their claim. Cease and desist, or I would charge them $100,000 for damages and bothering me. See the administrative process. By silence, they agreed to the terms. See definitions. See attached publicly filed unrebutted affidavits X, Y, and Z. I'm going to give you those too. So if anybody has, you just want to bullshit or whatever, you can go to the Salt Lake County Recorder's Office and look that stuff up. So then we talk about Fair Debt Collection Practices Act 1692G. In the ordinary course of business, you must provide an alleged debtor with proof of claim. Anything that is not denied is specifically admitted. You guys remember that too. Rule Civil Procedure 8B6. Anything that is not denied is specifically admitted. Okay? Which means I gave you an opportunity, man. I gave you 3 opportunities. 3 strikes, you're out, dude. Okay? The constructive notice should be served upon the adversary in the same manner that one would serve a summons or a lawsuit. Proof of service. I got all that. Okay? I got all my green cards. Should be executed and held for use as necessary for a future lawsuit. I got it. Notice was given and received. Anything that has not been rebutted is affirmed. Certified mail receipts are evidence of acceptance. Knowledge of the facts would naturally lead an honest man, a prudent person to make inquiry, constitutes notice of everything which is in such inquiry pursued in good faith would disclose. In other words, if you send me a document and say, hey man, you owe us money, and then you can't back it up, you are in trouble and you are operating under color of law. Okay? Twitchell versus Nelson, Lincoln versus Martin. Okay? Great National Bank. Okay. So we're only on page 10 and we're already at 25 minutes. So I'm going to stop it here. You know what? Let's go back here. Let's pause. Okay? This is a great one here. In the ordinary course of business, when good faith requires an answer, it is the duty of the party receiving a letter from another to answer within a reasonable time. Otherwise, he is presumed to admit the propriety of the acts mentioned in the letter of his correspondent and to adopt them, which means agree to them. That's from the Uniform Commercial Code. Okay? Silence is a species of conduct and constitutes an implied representation of the existence of facts in question. When silence is of such character and under such circumstances that it would become a fraud, it operates as an estoppel. Okay? Now, the very first enactment of Congress on page 1, statutes at large, incorporated the Declaration of Independence as the law of this country. To secure these rights, governments are instituted among men, deriving their powers from the consent of the governed. It's not debatable. It's not an argument. It's fact. Anything done to me without my consent, done under threat, duress, or coercion, is fatal, and remedy must be afforded. Okay? Then we have a bunch of descriptions. We have consent. Whoop. Let's see. Let's pause that. Okay? And then all this is Black's Law Dictionary from case law precedent. Okay, so res judicata, what does that mean? It means the matter's already been judged. It's already adjudicated and it's already been decided. What does stare decisis mean? It's decided. Policy of courts to stand by precedent and not to disturb a settled point. Okay? When a point of law has been settled by decision. It's already been decided, dude. What is estoppel? It means that the party is prevented by its own acts from claiming a right. It's pretty simple. It's right there. It's right there in the friggin' law books. And then it just goes into detail. You can read that. Okay? It's an agreement on and settlement of facts by force of entering into contract. Huh. Well, you know, hey, I gave you an opportunity, dude, to answer. Okay? What's an equitable estoppel? Man, that was a tough one. Equitable estoppel. The doctrine by which a person may be precluded by his act or conduct or silence when it is a duty to speak from asserting a right which he otherwise would have had. You know, you voluntarily decided to ignore me by tacit silence, tacit acquiescence. Prima facie. Oops. Let's let you pause. Okay. Prima facie. What is prima facie? Pause. Silence. Okay. Silence is stopped by. Such estoppel arises where person is under a duty to another to speak, or failure to speak is inconsistent with honest dealings. An agreement inferred to from silence rests upon the principle of estoppel. It's right there. Okay, it's all right there. So anyway, and of course, always certificate of service, and the affidavits we'll go into in the next one. Peace.